The moment Raymond Polk's hands went still, I knew it was over. He was sitting across from me in courtroom 4 of the Fulton County Probate Court, a man who had spent the last 8 months being paid very well to make sure I walked away with almost nothing. He had the confidence of someone who had never once considered losing. He picked up the document Veronica had just placed in front of him, turned to page 3, and stopped. He looked up at me. He looked back down at the page. His hands, both of them pressed flat against the table. Not dramatically, not the way it happens in movies, just quietly like a man who suddenly needed to feel something solid beneath him. It wasn't grief. Raymond Polk was not a man who grieved easily. What I was watching was something else. The specific stillness of a person who has just understood that the trap they thought they were setting had already been set around them months ago by the woman sitting across the table drinking water from a paper cup. I want to tell you something before I tell you the rest of this story. People say black women from the South don't cry, that we only know how to endure, that we were built for suffering the way oak trees were built for hurricanes. You bend, you don't break, and somewhere along the way, bending starts to feel like strength. That's not true. We cry. I have cried in grocery store parking lots and church bathrooms, and once memorably in the handicapped stall of a Delta terminal at Hartsfield-Jackson, because my husband had just been diagnosed with high blood pressure, and I didn't want him to see my face when the doctor said it. We just don't cry in front of our enemies, and I want to be very clear about something. By the time Darnell Monroe sat down in my living room 48 hours after I buried his father and started explaining to me what I was and wasn't going to receive from 38 years of my own life, he had already made himself my enemy. He just didn't know I knew that yet. That was his first mistake. Follow me until the end. And if this story finds you somewhere far from Atlanta, Georgia, I want to know where you're watching from. Leave it in the comments. Because what happened to me happens to women everywhere every day, and most of them never find out what I found out. Most of them never get to sit in a courtroom and watch the other side's lawyer press his hands flat against a table and go very, very still. I was born in Savannah, Georgia in 1960, the third of 6 children. My father welded steel for a living and came home smelling like metal and effort. My mother taught 3rd grade at the only school in our county that would hire a black woman with a teaching degree. We lived in a 3-bedroom house with 1 bathroom and a rule that was never written down but never needed to be. You work harder than everyone else because no one is going to give you points for being pitiful. I won a full scholarship to Spelman College in 1978. Accounting. I graduated with honors in 1982, took a job at a small construction firm in Atlanta, and spent the next 2 years learning that I was better at understanding money than almost anyone I worked with, and that almost none of them were going to tell me so. I met Gerald Monroe at a jazz concert in Little 5 Points in September of 1983. He was a doctoral candidate in economics at Emory, 30 years old, wearing a jacket that was slightly too big for him, and laughing at something his friend said with his whole face. I thought that is a man who is not performing anything, which if you have spent any time in Atlanta social circles, you will understand is a remarkable quality. We were married in June of 1985. Gerald was the dreamer. I was the one who made the dreams have budgets. He would come home from a faculty meeting, excited about a conference in Barcelona or a colleague's research on emerging markets, and I would listen carefully and then ask, what does that cost, and when does it need to happen? Not to shut him down, to figure out how to make it possible. That was what we were to each other for 38 years. He imagined it. I built the structure that held it up. By 1994, I was CFO at a mid-size real estate firm in Midtown Atlanta, earning $112,000 a year. Gerald was a tenured professor at Emory, earning $68,000. From that year until 2008, I was the primary earner in our household. We never made it strange. It was just math, and we both understood math. In 1992, we bought our house in Buckhead, $180,000 down a $220,000 mortgage. We paid it off in 2001. By 2024, that house was worth $1.4 million. In 1998, I convinced Gerald to put $95,000 into a small commercial property in Decatur. We sold it in 2019 for $680,000 and reinvested the proceeds into a portfolio I managed myself. By early 2024, that portfolio was worth $890,000. In 2004, Gerald purchased a $500,000 life insurance policy through Emory's Faculty Benefits Program. He named me as the sole direct beneficiary. Not through the will. Directly. That distinction will matter later. In 2005, Gerald's mother passed and left him $140,000. He came home from the lawyer's office wanting to give the boys a chunk of it. I sat with him at the kitchen table, the same table where we had made every significant financial decision of our adult lives. And I said, Gerald, those boys have 2 working legs and 30 years ahead of them. This money is ours. He thought about it for 2 days. Then he agreed. Darnell found out about the $140,000 that Christmas. I watched him process the information. The way his face went briefly carefully neutral before he smiled and said, "That's great, Dad." I filed that moment away in the part of my mind I kept for things I wasn't ready to use yet. By the end of 2023, Gerald and I had built the following together from nothing. The Buckhead house, $1,400,000. The investment portfolio, $890,000. Our joint retirement accounts, $340,000. The life insurance policy, $500,000. Cash in our joint checking and savings, approximately $80,000. Total $3,210,000. I want you to hold that number. I want you to remember that it came from a welder's daughter from Savannah and a professor who wore jackets that were slightly too big. It came from 38 years of Saturday mornings at the kitchen table, saying no to the things that felt good, and yes to the things that compounded quietly in the background while we weren't looking. I want you to remember that number because of what came next. Gerald had 2 sons from his first marriage, which ended in 1984, a year before he met me. Darnell Monroe was 42. He ran his own real estate law practice in Buckhead, which meant he knew exactly how estate law worked and exactly what he was doing when he did what he did. He had been divorced twice, most recently in 2021. He was paying $4,200 a month in child support and $6,800 a month on the mortgage of a house in Sandy Springs he could not afford and would not admit he could not afford. His personal debt, as I would later learn, totaled approximately $380,000. Kevin Monroe was 38, lived in Charlotte, worked in marketing. Quieter than his brother. Not greedy by nature, I think, but also not the kind of man who had ever developed the habit of deciding things for himself. He had spent his whole life standing slightly behind Darnell. The problem with spending your whole life standing behind someone, is that you start going wherever they go without ever asking where. The relationship between me and Gerald's sons was what I privately called hallway peace. Civil enough to pass each other without incident, not close enough to be honest. I had been their stepmother for 30 years. I had cooked Thanksgiving dinners and sent birthday cards and sat in the front row at Darnell's law school graduation. I had never pretended to be their mother, and they had never pretended to need one. But I watched them. That was something Gerald never quite learned to do with the people he loved. Watch them. He was too busy being warm. I watched the first time Darnell asked about the will in 2018, the same week Gerald mentioned to me that his doctor had flagged his blood pressure. I watched the way Kevin stopped meeting my eyes at family dinners sometime around 2022. I didn't say anything about either of those things. I just remembered them. Gerald died on March 14th, 2024. A heart attack. Sudden, catastrophic, no warning that meant anything until it was too late. He was 68 years old and had been given a clean bill of health 3 months earlier. I sat with him alone that last night. Darnell and Kevin arrived after he had already lost consciousness. They stood at the foot of the bed in their coats like men who had come to confirm something rather than say goodbye. I don't say that to be cruel. I say it because it's what I saw. 48 hours after the funeral, Darnell called and said he needed to come by to discuss practical matters. He arrived with Raymond Polk, 55 years old partner at Polk & Associates on Peachtree Road, a man who had graduated from Emory Law in the same class as Darnell Monroe in 2005. He carried a leather briefcase that I recognized as expensive in the way that things are expensive when the person carrying them needs you to notice. Kevin came too. He sat in the armchair by the window and did not look at me directly for the entire meeting. Darnell set a bound document on my kitchen table, 47 pages. The cover sheet read, Estate of Gerald T. Monroe, Proposed Distribution Summary. He explained in the measured tone of a man who has rehearsed this that Gerald had signed a revised will on January 19th, 2024, 54 days before he died. Under this will, the Buckhead house valued at $1,400,000 would pass to Darnell and Kevin jointly. I would have 90 days to vacate. The investment portfolio valued at $890,000 would be distributed 70% to Darnell and Kevin, 30% to me. My share $267,000. The joint retirement accounts valued at $340,000 would go 60% to the sons, 40% to me. My share $136,000. The remaining cash after legal and administrative fees would come to approximately $30,000 for me. Total for Sarah Monroe after 38 years, $433,000. Neither of them mentioned the life insurance policy. They knew they couldn't touch it. But they didn't mention it, which told me they had calculated whether they could and had decided not to show that hand. Raymond Polk did not look at me once during the presentation. He kept his eyes on his documents the way a man keeps his eyes on the floor when he knows the ceiling is about to come down. Darnell finished speaking. He folded his hands on my kitchen table with the patience of someone waiting for a reaction he had already scripted a response to. I waited a moment, then I said, Mr. Polk, which firm drafted this document? Our office, he said, at Mr. Monroe's request. Thank you, I said. I'll need some time to read through it carefully. Darnell blinked. That wasn't what he had prepared for. He had prepared for tears or anger or the particular kind of overwhelmed silence that passes for agreement when a person doesn't know they have options. He had not prepared for a 64-year-old woman to pick up the document, thank him politely, and show him to the door. They left at 4:15 in the afternoon. By 11 o'clock that night, I had read all 47 pages. Twice. I was sitting at the same kitchen table with a cup of tea that had gone cold, and I had the document open to page 31. Page 31 was the signature page. I had watched Gerald sign his name thousands of times over 38 years. Birthday cards, Christmas checks, the mortgage documents in 1992, his hand steady and deliberate. The refinancing papers in 1999 slightly faster. The last Christmas card he signed in December of 2023 with the small characteristic tremor in his right hand that had developed after a minor episode in 2022. The slight hesitation before the pen lifted the way the tail of the G drifted just barely left before correcting. The signature on page 31 had none of that. It was smooth, even, completed approximately 40% faster than Gerald's documented signing pace, according to what I would later learn from Thomas Greer. No tremor, no hesitation, no drift. It was the signature of a man whose hand did not shake. Gerald's hand shook. I closed the document. I sat with that for a few minutes. Not with anger, not yet, but with something heavier and quieter. The kind of feeling you get when something you suspected turns out to be true, and you realize you were hoping you were wrong. Then I picked up my phone and called Patricia. I have made a lot of phone calls in my life that mattered. That one I think mattered most. Patricia Holloway and I have been friends for 47 years. We met the first week of freshman orientation at Spelman in September of 1978, standing in the same registration line with the same look on our faces. The look of girls who had been the smartest person in every room they'd ever been in and had just arrived somewhere that would require them to recalibrate. We recognized each other immediately. We have been recognizing each other ever since. Patricia went on to law school at Howard, then a doctorate, then a chair at Georgia State's College of Law, where she has taught estate law and property rights for the last 22 years. She is not a practicing attorney. What she is the person I called at 11:23 on the night of March 16th, 2024, when I had a cold cup of tea and a 47-page document open to page 31. She answered on the second ring. Patricia always answers on the second ring. She says the first ring is for people who are already holding the phone. I read her the signature analysis I had done myself. The tremor Gerald had developed the tail of the G, the pace. I didn't editorialize. I just described what I was looking at. She was quiet for 5 seconds. Sarah, I know. Do not sign anything. Not one page. Not an acknowledgement. Not a receipt. Nothing. I know. I'm going to give you a name in the morning. She's the best I know for this kind of thing. You call her first thing. We talked for 2 more hours after that. Not about the documents. About Gerald. About the way he used to mispronounce quinoa on purpose because it made me laugh. About the time he drove 4 hours to Savannah with me when my mother was sick and sat in the hospital waiting room for 9 hours reading a paperback without complaining once. By the time I hung up, it was almost 2 in the morning, and I had cried exactly as much as I needed to, and not 1 second more. Then I washed my face, went to bed, and started planning. The name Patricia gave me was Veronica Shaw, 52 years old, managing partner at Shaw and Whitfield on West Peachtree Street. She had spent 20 years handling exactly this kind of case. Families turning on their own people, exploiting grief, taking advantage of someone who didn't know yet that they had options. She had a reputation in the Georgia legal community for being methodical in a way that opposing counsel tended to underestimate, until the moment they stopped underestimating her, which was usually too late. She was also, Patricia mentioned almost as an afterthought, the kind of woman who wore reading glasses on a chain around her neck and kept a yellow legal pad on her desk at all times, and had never once in 20 years of practice lost a will contest that she had taken to trial. I called her office on the morning of March 17th. I had an appointment by afternoon. We met on March 20th, 2024 in her conference room on the 14th floor of a building that looked out over Midtown. I brought the 47-page distribution summary. I brought the original 2018, the one Gerald and I had signed in front of 2 witnesses at the offices of Clarence Webb at Georgia Estate Planning Group, the will that left everything to me with a structured trust of $200,000 for each son to be distributed at 50 and 55. I had kept our copy in the fireproof safe in our bedroom closet for 6 years. Gerald had always been slightly amused by my fireproof safe. He called it the vault. I called it Tuesday. Veronica put the 2 documents side by side on the conference table. She looked at the signatures for a long time without speaking. Then she looked at the dates. Then she took off her reading glasses. They were on the chain exactly as Patricia had said, and she looked at me. Do you have a number for Clarence Webb? Saved since 2018, I said. She almost smiled. Good. I'm going to need 3 things from you. Everything you can remember about Gerald's physical condition in the 6 months before he died. Any financial documents you have access to, account statements, anything in both your names. And patience. This is going to take time, and it's going to require you to behave in every interaction with Darnell and Kevin Monroe as though you have no idea what we are doing. Can you do that? I thought about 40 years of quarterly tax filings, about budget meetings where I was the only woman in the room, and I had learned very early that the most powerful thing I could do was to let the other people at the table believe they were leading the conversation. Yes, I said, I can do that. The first thing Veronica did was hire Thomas Greer, 61 years old forensic document examiner, 25 years of experience, testified in over 300 cases in Georgia and federal courts. He had worked with the FBI, with the Georgia Bureau of Investigation, and with more estate attorneys than he could count. He used a digital microscopy system and a software platform called Forensic Pro to analyze handwriting, the same tools used by federal law enforcement to authenticate questioned documents. He received 2 items from Veronica's office: a certified copy of the January 19th, 2024 will and a comparison package of 6 documents confirmed to bear Gerald Monroe's authentic signature, all dated between 2021 and 2023. His report came back on March 28th. I read it at the kitchen table with a cup of coffee that I actually remembered to drink while it was hot, which tells you something about the state I was in. The findings were technical and precise in the way that findings from people like Thomas Greer always are, which is to say they were written for a courtroom, but they hit me like something much simpler than language. The signature on the January 19th document showed a 67% reduction in pen tremor compared to Gerald's authenticated samples from the same period. The pressure pattern at the connecting stroke of the capital G, the specific place where Gerald's tremor always showed up most clearly, was inconsistent with every confirmed sample in the comparison set. The completion time estimated from ink deposit patterns was approximately 40% faster than Gerald's documented signing pace. Thomas Greer's conclusion in the careful, qualified language of expert witnesses everywhere. It is my professional opinion, expressed with a high degree of scientific certainty, that the signature appearing on the document dated January 19, 2024, does not reflect the natural, unassisted handwriting of Gerald T. Monroe. I sat with that sentence for a long time, not because I was surprised. I had known what that report was going to say from the moment I sat at this same table 12 days earlier and looked at page 31. I had known it the way you know things when you have spent 38 years watching one particular person's hand move across paper. What I felt sitting there was not satisfaction. It was grief of a specific and complicated kind. The grief of having something you hoped wasn't true, confirmed in 34 pages of forensic analysis. Gerald's son had forged his father's name, had stood in a room with their dying father and guided his hand or someone else's hand across a line that wasn't his to cross. And Kevin had been there, and neither of them had stopped it. I finished my coffee. I called Veronica, and then I moved to the next step. The next step was Calvin Stokes, 48 years old, forensic accountant at Stokes Forensic Accounting in Atlanta, a firm that specialized in tracing financial movements in estate disputes and elder abuse cases. Veronica used him regularly. She said he was the kind of man who found things in bank statements that other people looked at and saw nothing the way certain people can look at a forest and see individual trees. What Calvin found when he went through Gerald's personal account records for the 14 months between January 2023 and March 2024 was this: 11 transactions, total amount $127,400, each one categorized in Gerald's records as legal consulting fees, payments to an LLC registered to Darnell Monroe's home address. There were no contracts, no invoices, no engagement letters, no documentation of any kind that Gerald had received any legal services in exchange for that money. There were also 4 additional transfers totaling $43,000 from Gerald's personal savings to a personal account belonging to Kevin Monroe, categorized as personal loan. No promissory note, no repayment schedule, no record that Gerald had ever expected to be repaid. $170,400 had moved from Gerald Monroe's accounts to his son's accounts in the 14 months before he died, in the months when his health was declining, in the months when he was, as I would later learn from his medical records, sometimes not fully alert in the mornings after taking his blood pressure medication. These transfers weren't gifts, and they weren't loans. Under Georgia's Elder Protection Statute, the law that specifically criminalizes financial exploitation of older adults by people in positions of trust, they had a different name entirely. I read Calvin's report on a Tuesday evening in early April. I was sitting in Gerald's study. I had started sitting there in the evenings in his chair because it was the room in the house that still smelled most like him. There was a photograph on his desk that he had kept there for 11 years, the two of us at our 25th anniversary dinner, laughing at something I couldn't remember anymore. I looked at it for a long time after I finished reading. Then I put the report in the fireproof safe next to Thomas Greer's report and the 2018 will and went to make dinner. Through all of this, through March and April, and into May, I answered Darnell's phone calls. He called 3 times in April. Each time his voice carried the particular warmth of a man who has convinced himself that what he is doing is reasonable and perhaps even generous, and who needs the other person to confirm this. He wanted to know when I'd be ready to sit down and talk through the transition. He used the word transition the way people use words when they want to describe a thing without having to name it. Each time I said, "I need a little more time, Darnell. I just lost my husband." There is no response to that sentence. I had learned this about grief from the outside long before I needed to use it from the inside. There is simply no way to argue with a woman who has just told you she is grieving. You can feel whatever you feel, but you cannot say it. Darnell Monroe, who was a lawyer and understood leverage, understood this too. So he said, "Of course, and take all the time you need." And then he waited. He was not good at waiting. That was useful. On April 28th, Darnell suggested a family dinner at my house. He and Kevin arrived with pizza and a bottle of wine, and the careful performance of men who want something and have decided that warmth is the most efficient route to it. We sat around the kitchen table, my kitchen table, the one where Gerald and I had built a $3,210,000 life, one decision at a time, and Darnell told me he was worried about me, that he wanted to make sure I didn't have to stress about finances, that he and Kevin were there for me in whatever way I needed. Kevin nodded at everything his brother said. He was wearing a blue Christmas sweater I had given him 3 years earlier. He had not looked at me directly since he walked in. In the back of my mind, while Darnell talked Thomas Greer's report in the fireproof safe, Calvin Stokes's 14 months of transactions, $170,400. The signature that wasn't Gerald's. "I know you are," I told them. "I'm so grateful to have family." I stood up and refilled their water glasses. Neither of them noticed that my hands were completely steady. On May 15th, 2024, I sat down with Veronica Shaw and Clarence Webb in Veronica's conference room, and we finalized the legal strategy. It had 3 parts. Part 1. File a formal will contest in the probate court of Fulton County on the grounds of signature fraud supported by Thomas Greer's forensic report and lack of testamentary capacity, meaning Gerald's ability to fully understand what he was signing had been compromised by his medication, supported by his medical records, showing the effects of his blood pressure regimen beginning November 2023. Part 2. Simultaneously file a motion for asset freeze. An emergency injunction preventing Darnell and Kevin from accessing the investment portfolio or retirement accounts while the contest was pending. This was critical. Without the freeze, they could begin liquidating assets the moment the will entered probate. Part 3. Report the $170,400 in undocumented transfers to Adult Protective Services of Georgia under the state's Elder Financial Exploitation Statute, which carries significant criminal penalties. The life insurance policy, all $500,000 of it, required none of this. It sat outside the estate, entirely a direct beneficiary designation that no will real or forged could touch. Gerald had done that in 2004 without either of us knowing 20 years later how much it would matter. I signed the authorization forms for Veronica to proceed. My handwriting was even. My hand did not shake. I thought about Gerald's hand shaking the last Christmas card. I thought about someone deciding to use the vulnerability of an aging man's body as an opportunity. I thought about 47 pages sitting on my kitchen table and the look on Darnell's face when I thanked him and showed him to the door. "Take all the time you need," he had said. I had taken exactly what I needed. There is one more thing I want to tell you about this period, about the weeks between filing and the beginning of what came next. Patricia came over every Thursday evening in April and May. She would arrive at 6 o'clock with takeout from the Ethiopian place on Ponce de Leon that we had been going to since 1994, and we would sit in Gerald's study. I was always in his chair by then. She always took the small love seat by the window, and she would go through the documents with me, not as a lawyer, as a translator. She explained what it meant when a court found that someone lacked the capacity to understand what they were signing, and why proving that was sometimes more powerful than proving outright forgery. She explained what undue influence meant when someone in a position of trust steers an older person toward a decision that benefits the influencer rather than the person themselves. She explained what would happen in the courtroom, who would speak when what Darnell's side would try to argue, and why those arguments were going to be difficult to make in the face of what we had. And one Thursday evening in May, about a week before the papers were filed, she put down her legal pad and looked at me across the room. "Sarah, when he says the worst thing and he will say something, some version of the thing he already believes about you and your right to be in that family, you cannot react. Not a word, not a breath, not a look. You understand?" I understood. I had spent 40 years in rooms where people underestimated what I knew and what I had built. I had learned in those rooms that the most powerful response to someone who expects you to break is to simply not break. "Silence is winning," she said. "I know I said. Gerald taught me that." She looked at me for a moment. Then she picked up her legal pad and we went back to work. Veronica Shaw filed the papers on the morning of Thursday, May 22nd, 2024. I was not there. She had advised me not to be, and I had agreed because Veronica Shaw had 20 years of experience, and I had learned somewhere around age 40 that the most valuable thing you can do with good advice is take it. I was at home instead in Gerald's study going through his books, not looking for anything in particular, just being in the room where he had spent his evenings running my fingers along the spines of things he had loved. The filing included the following: a 12-page will contest petition arguing signature fraud and lack of testamentary capacity. Thomas Greer's 34-page forensic report with his findings on pen tremor pressure patterns and signing pace. A certified copy of the original 2018 will authenticated by Clarence Webb. 14 months of bank statements documenting $170,400 in transfers from Gerald's personal accounts to his son's with a forensic accounting analysis by Calvin Stokes showing no corresponding documentation of services rendered or loan agreements. Gerald's medical records from November 2023 through March 2024 obtained under court order showing the blood pressure medication regimen and its documented short-term cognitive effects. And a motion for emergency asset freeze requesting that the court prevent any disbursement from the estate's investment portfolio or retirement accounts, pending the outcome of the contest. The asset freeze was granted 72 hours later. I found out on a Saturday morning. Veronica called me while I was in the garden deadheading the roses I had planted along the back fence in 1998. The same roses Gerald used to walk past on his way to his outdoor chair on Sunday mornings, always touching one of them briefly with 2 fingers, the way you touch something you're glad is there. I had my gardening gloves on and dirt on my knees, and when Veronica said the freeze has been approved, I sat back on my heels and looked at those roses for a long moment. "Thank you, Veronica," I said. "Don't thank me yet," she said. "They're going to push back." Darnell called at 4:47 that same afternoon. I knew it was him before I looked at the phone. There are phone calls you can feel coming the way you can feel a change in the weather. Something in the air shifts slightly and you know. "What are you doing?" His voice was not the careful warmth of the April dinners. It was something stripped of its coating. "What are you doing to this family? Darnell, you are not blood. Do you understand that you are not blood? And you have no idea what you're interfering with. Dad would not have wanted this. He would be ashamed of this." I was sitting in Gerald's chair. The window in front of me looked out onto the back garden, and I could see the roses from where I sat catching the late afternoon light. In that particular way they did in May when the angle was right. The light coming low and golden through the gap in the fence, making everything look briefly like something worth keeping. "I understand what you're saying, Darnell," I said. "I'll be in touch through my attorney." I ended the call. I sat there for a few minutes with the phone in my lap looking at the roses. Gerald had never once in 38 years suggested that I was not family. He had never used the word blood as a boundary. He had said on our 20th anniversary at the restaurant on Peachtree, where the bread was always too good, and we always ordered too much of it, "Sarah, you are the best decision I ever made, and I want you to know I know that." I put the phone face down on the desk and went back to the garden. On June 8th, my neighbor Helen Carter called me. Helen was 70, had lived 2 houses down since 1996, and was the kind of woman who noticed things and told you about them not out of nosiness, but out of genuine old-fashioned neighborly concern. She had brought me a casserole the week after Gerald died and sat with me for 2 hours without feeling the need to fill the silence with words. She told me that the previous afternoon Darnell had come to her door. He had asked whether I had seemed confused lately, whether I had been meeting with strangers, whether she had noticed anything that might suggest I was not quite myself. I thanked her. I hung up. I called Veronica. "He's building a competency argument," she said without surprise. "He wants to claim you're not mentally fit to contest the will. It's a standard counter move. We're going to get ahead of it." Getting ahead of it meant scheduling a voluntary cognitive evaluation, a request before Darnell could file his own motion demanding one. Veronica arranged for Dr. Josephine Kim, a licensed clinical neuropsychologist on the court's approved examiner list, to conduct the assessment. I went on June 11th. I sat in a quiet office in a medical building in Decatur and answered questions and completed tasks for 2.5 hours. Dr. Kim was professional and unhurried and gave nothing away, which I respected. Her report came back on June 14th. No indicators of cognitive impairment. No signs of diminished decision-making capacity. Mini mental state examination. Score 30 out of 30. The report was filed with the court on June 16th. Darnell received a copy through his attorney on June 17th. Kevin called me that evening. Not at Darnell's direction, I would later understand. On his own. I thought about the blue Christmas sweater he'd worn to that April dinner, the one I'd given him 3 years earlier, and the way he hadn't been able to look at me across the table. He was quiet for a moment after I answered the kind of quiet that has something behind it. "Sarah," he said, "I'm sorry it's gotten this far." It was not an apology for what had happened. Not yet. But it was the first crack in a wall that had been standing for months, and I heard it for what it was. "I hear you, Kevin," I said, and left it there. On July 15th, Raymond Polk made the worst professional decision of his career. In his formal response to our will contest petition filed on behalf of Darnell Monroe Polk, included a 4-minute video recording as exhibit evidence. The video had been made by Polk and Associates at their Buckhead office on January 19th, 2024, the same date as the contested will. The stated purpose of the video, as Polk described it in his filing, was to document Gerald Monroe's voluntary and informed participation in the signing of the revised estate documents. Polk believed the video would demonstrate that Gerald was lucid willing and fully aware of what he was signing. What the video actually demonstrated was something else entirely. Veronica called me the evening she received the filing. Her voice had the particular quality it got when something significant had happened. Not excited, not triumphant, just very, very precise. "They filed a video," she said. "I heard you. What's on it? Come in tomorrow morning. Bring Thomas Greer if you can reach him tonight." I reached Thomas Greer at 7:45 that evening. He was at Veronica's office by 9 the next morning. We watched the video together, the 3 of us in the conference room where I had first sat down with Veronica 4 months earlier. 4 minutes and 11 seconds. Gerald sitting across a desk from Raymond Polk Darnell standing to his left. The documents spread on the desk in front of him. At the 1-minute 12-second mark, Gerald looked at the papers and said, "What is this?" Darnell said, "It's paperwork for your investments, Dad. Just go ahead and sign. Gerald looked at the papers for a moment. Then he reached for the pen. At the 2-minute 47-second mark, Gerald looked up again and said, "What did you say this was?" Darnell said investment documents, Dad. Right there on the line. Gerald signed. Thomas Greer watched the video twice more after that, taking notes on his legal pad. He noted that Gerald's gaze was unfocused for significant portions of the recording. He noted the characteristic rightward drift of Gerald's eyes away from the documents and toward the window that he had come to recognize from reviewing Gerald's medical records as consistent with the morning cognitive fog documented by Gerald's physician as a side effect of his medication at higher doses. He noted that at no point in 4 minutes and 11 seconds did Gerald Monroe read a single word of the documents placed in front of him. He didn't know what he was signing, Thomas said. He said it quietly without drama, the way a person states a fact that doesn't require emphasis. No, I said, he didn't. We sat with that for a moment, the three of us in that conference room, and then Veronica picked up her yellow legal pad and started writing. That evening she called me at home. Sarah. They submitted that video to prove Gerald was competent. What it actually proves is that Darnell told him twice on camera that he was signing investment documents. Gerald asked twice what he was signing. Darnell did not tell him the truth either time. That is undue influence. That is potentially fraud. That video is now the single most important piece of evidence in our case, and Raymond Polk put it in front of the court himself. I was in the garden again. Late evening, the light going down behind the fence, the roses closing for the night. How does that happen? I said. How does a lawyer do that? Because he watched that video, Veronica said, and saw what he wanted to see. He saw Gerald sitting upright and holding a pen. He didn't see what you and I and Thomas see when we watch it. What's that? A man who trusted his son. On July 10th, 5 days before Polk filed the video as it happened, though none of us knew that yet, Kevin Monroe walked into Veronica Shaw's office on West Peachtree Street without an appointment. The receptionist called Veronica out of a client meeting. Kevin was sitting in one of the chairs in the waiting area in a gray jacket, his hands between his knees, looking like a man who had made a decision and was now living in the 30 seconds after it. Veronica brought him into a small conference room. She called me immediately after. "Kevin Monroe just came in," she said. "He wants to testify for you." I sat down. I was in the kitchen. I sat down in one of the chairs at the table and put my hand flat on the surface, my kitchen table, the one that had seen 38 years of decisions, and I breathed. What did he say? He said he was there on January 19th. He said Darnell had been planning it since October of 2023 when Gerald's morning alertness started deteriorating. He said Polk drafted the new will at Darnell's direction. He said they chose that particular morning because Gerald had taken his medication early and was, in Kevin's words, not all the way there yet. He said he stood in the room and he watched it happen and he didn't say anything. She paused. He said he's been carrying it since March. I didn't say anything for a moment. I was thinking about Kevin in his blue Christmas sweater at my kitchen table in April, not looking at me. I was thinking about the phone call in June. I'm sorry it's gotten this far and what it had cost him to make it and why he had made it anyway. Is he credible? I asked. As a witness, he was present. He has specific details that match our evidence exactly. And judges respond to a witness who is testifying against their own interest. A pause. Yes, he's credible. Okay, I said. Sarah, are you all right? I looked at the table under my hand. The small scratch near the edge that had been there since 2003 when Gerald set down a stapler without looking. The ring mark near the center that we had never quite gotten out from a Thanksgiving 20 years ago. I'm all right, I said. What do we do next? On September 18th, 3 days before the trial date, Raymond Polk filed a motion to withdraw from the case. No explanation was given publicly. In legal circles, when a motion like that arrives 3 days before trial, the explanation is understood without being stated. The attorney has assessed the evidence, calculated the odds, and determined that continuing to represent his client is no longer in his own professional interest. The Georgia State Bar takes a dim view of attorneys who assist in the execution of documents later found to involve fraud. Raymond Polk had graduated from Emory Law in 2005. He had a license he intended to keep. The motion was granted. Darnell Monroe would walk into courtroom 4 of the Fulton County Probate Court on September 21, 2024, without an attorney. Veronica called to tell me. She was, as always, precise and unexcited. But at the end of the call, before she hung up, she said something she had not said before in 6 months of working together. "Sarah, I've handled 63 will contests in 20 years. I want you to know that I have never not once seen opposing counsel hand us a case the way Polk handed us this one. That video, 3 days before trial." A brief pause. "Your husband was a smart man." "He was," I said, "but so are you." I thanked her and hung up. Then I went to the fireproof safe in the bedroom closet, the one Gerald had called the vault, and I opened it, and I took out the photograph I had put there 3 weeks earlier when I was reorganizing the documents. It was a small photograph, the kind printed on regular paper, creased slightly at one corner. Gerald and me at our 25th anniversary dinner, both of us laughing at something neither of us could have told you anymore. I put it on his desk in the spot where he had always kept a photograph, and then I went to get ready for what was coming next. Courtroom 4 of the Fulton County Probate Court is a small room that takes itself seriously. I had been in courtrooms before depositions closings the ordinary legal machinery of a financial career, but I had never sat in one knowing that everything I had built was on one side of the room and everything I stood to lose was on the other. Dark wood paneling, high ceilings, fluorescent lights that cast everything in a slightly flattening light, the kind that makes everyone look like a slightly less resolved version of themselves. The room smells like old paper and central air conditioning, and the particular stillness of a place where consequential things happen regularly enough that the walls have stopped being impressed by them. I arrived at 8:15 on the morning of September 21st, 2024, 45 minutes before the proceeding was scheduled to begin. Veronica was already there, her yellow legal pad on the table, her reading glasses on the chain around her neck. 2 copies of every document we had organized and flagged and reorganized over the previous 6 months, stacked with the precision of someone who has never once lost a file. Patricia was in the gallery, second row, in the gray blazer she wore when she meant business. We had not discussed whether she would come. She had simply been there when I arrived. Darnell came in at 8:40. He was wearing a dark suit and carrying a briefcase, and he walked with the deliberate steadiness of a man who had decided somewhere between his car and this room that he was going to behave as though he was not afraid. He sat down at the respondent's table alone, no attorney beside him, a yellow legal pad of his own in front of him, and he did not look at me. Kevin came in through the side door at 8:50 and took his seat in the witness area. He looked at me once briefly and then looked at the table in front of him. He was wearing a dark blue jacket. Not the Christmas sweater. Something he had chosen for this specific day. Judge Andrea Morrison entered at exactly 9 o'clock. 58 years old, 22 years on the Fulton County bench. A woman who had the quality that the best judges share, the ability to be completely still in a way that is not passive, but rather the opposite of passive attention concentrated to a point. She had reviewed the filings. She took her seat, looked at both tables, and said, "We'll begin." Darnell spoke first. I will give him this, composed. He had prepared. Without Polk to carry the argument, he had built his own version of it, and he delivered it with the practiced confidence of a man who had spent his career in rooms where the ability to sound certain was worth something. He told Judge Morrison that Gerald had expressed in private conversations over many years a desire to ensure that the Monroe family assets remained within the bloodline. That I had, over the course of our marriage, exercised a controlling influence over Gerald's financial decisions. That the original 2018 will did not reflect Gerald's true intentions, which he had finally been able to act on in January of 2024, when Darnell said Gerald was clear-minded, willing, and fully aware of what he was doing. He said several other things. I listened to all of them. I did not move. I did not change my expression. I held Patricia's instruction in my mind like a compass bearing when he says the worst thing you cannot react. And then Darnell said the worst thing. He turned slightly so that he was addressing not just the judge, but the room, and he said, "Sarah Monroe is not blood, Your Honor. With respect, she is not a Monroe. She has never been a Monroe. And my father in his final months made the decision that this family's legacy should pass to the people who carry that name." The room was quiet. I was quiet. Veronica was quiet in the specific way of someone who is letting a thing land before she picks it up. 38 years. The kitchen table. The roses. The mortgage paid off in 2001. The $95,000 in Decatur that became $680,000. Gerald's hand on my face in the hospital waiting room the night my mother had her second stroke. You are the best decision I ever made. I sat with all of that, and I did not move, and I did not speak, and I looked straight ahead. Then Veronica stood up. "Your Honor," she said, "we'd like to call our first witness." Kevin Monroe was sworn in at 9:47 in the morning. He sat in the witness chair with his hands folded on the railing in front of him, and he looked at Veronica, and he told the truth. He told it plainly, without drama, in the specific detail of someone who has been carrying a memory for months and knows every corner of it. He described the conversation with Darnell in October of 2023, when Darnell had laid out the plan. He described the morning of January 19th. Gerald's condition when they arrived at Polk's office, the way he had reached for his coffee twice without remembering he'd already drunk it, the way he'd asked what the papers were. He described Darnell's answer. He described watching his father sign a document he did not understand while his son told him it was something else. He said, "I stood there, and I let it happen. I didn't say anything. I've thought about that every day since March." Darnell did not stand up. He did not interrupt. He sat at his table and he looked at the surface of it, and for the first time since I had known him, for the first time in 48 hours of grief and 6 months of legal proceedings, and 30 years of careful managed distance, he looked like something other than what he had always performed being. He looked like a man who understood what he had done. Veronica concluded her examination of Kevin at 10:22. Darnell had the right to cross-examine. He declined. Judge Morrison noted the declination for the record. We recessed for 15 minutes. In the hallway, Patricia found me and stood beside me without saying anything, which was exactly what I needed. After a moment, she handed me a bottle of water. I drank half of it. We went back inside. Veronica presented the documentary evidence in sequence methodically the way she did everything. Thomas Greer's forensic report, Calvin Stokes's financial analysis, Gerald's medical records. She walked Judge Morrison through each element with the patience of someone who has learned that the most powerful arguments are the ones that don't need to be argued, only shown. Then she said, "Your Honor, we have one final piece of evidence to submit." She reached into the folder at the bottom of the stack, the folder I had watched her place there that morning with particular care, separate from the others, and she removed a single sheet of paper in a clear, protective sleeve. "Petitioner's Exhibit 14, she said. A handwritten letter authenticated by forensic document examiner Thomas Greer as consistent with Gerald Monroe's handwriting from the period October through November 2023, discovered by Mrs. Monroe on September 1st of this year, inside a copy of the autobiography of Malcolm X from Mr. Monroe's personal library. Page 284. She put on her reading glasses. She read it slowly, not for effect. Veronica Shaw was not a woman who did things for effect. She read it slowly because it deserved to be read that way, because the words in it had been written by a man who knew he was running out of time and had chosen to spend some of what was left writing them down. "Sarah, if you're reading this, I'm probably gone and I wasn't able to say the things I meant to say out loud. I've been watching what's been happening and I didn't want to believe it. A father doesn't want to believe it. But I've seen the way Darnell looks at the bank statements when he thinks I'm not paying attention. I've seen the way Kevin goes quiet when he should speak. I know what that means. I've known for a while. You have been with me for 38 years. You chose me when I had nothing worth choosing. Everything we have, the house, the investments, everything you built that alongside me. You kept the books when I would have spent the money. You made the calls I didn't know to make. That isn't the Monroe family legacy. That is our life, yours and mine. I didn't protect you the way I should have while I was here to do it. That's on me. I hope what I've left behind is enough for you to protect yourself. Don't let them take what's yours. I love you. I always have. Gerald. Veronica lowered the paper. The courtroom was completely silent. Judge Morrison was looking at her desk. Not at the paper, not at either table. At her desk, the way a person looks at something neutral when they need a moment to be a human being before they go back to being a judge. I was looking at the window on the far side of the room. There was a rectangle of September light coming through it, pale and clean, falling across the floor. At an angle that reminded me for a reason I couldn't have explained of the light in our kitchen on Sunday mornings, when Gerald was still there to make coffee badly and set it in front of me like an offering. My hands were on the table. I could feel them. I did not move them. The tears came quietly without announcement, the way grief comes when it has been waiting in an orderly fashion for the appropriate moment. I did not wipe them. I did not look away from the window. I let them come, and I stayed where I was, and I did not make a sound. In my peripheral vision, I was aware that Darnell was not looking at his table anymore. He was looking at me. I did not look back. Judge Morrison called a recess at 11:40. We reconvened at 1:15. The afternoon session was shorter. Veronica presented the final elements, including the JMS Holdings account, which required some explanation. In September of 2023, Gerald had visited a cardiologist independently without telling me and had received information about his heart that he had also not told me. 2 weeks after that appointment, he had contacted First Peach Wealth Management and established a limited liability company called JMS Holdings, which stood for Josephine Monroe Savings, and transferred $340,000 from our joint retirement accounts into a protected trust with me as the sole beneficiary. He had done this in September of 2023 when he was fully alert, fully competent, and fully aware of what he was putting in motion. He had done it before the medication increase, before the cognitive fog, before January 19th. He had done it because he had seen a cardiologist, and he understood that time was becoming a variable he could not control, and so he had controlled the things he could. Darnell had not known about JMSE Holdings. He had never known it existed. He had spent 8 months fighting over an estate whose most significant protected asset he had never seen on any document, because Gerald had made sure he wouldn't. When Veronica finished presenting the JMS Holdings evidence, I allowed myself one small thing. I looked at the window again at the September light, and I thought you brilliant, careful, stubborn man. Judge Andrea Morrison issued her ruling on October 28, 2024. The will dated January 19, 2024 was declared invalid on 2 independent grounds: insufficient testamentary capacity supported by medical records and the forensic video analysis, and undue influence supported by Kevin Monroe's testimony and the documented pattern of financial transfers in the 14 months preceding Gerald Monroe's death. The controlling document was the 2018 will. The estate passed to Sarah Josephine Monroe in its entirety, subject to the structured trust provisions for Darnell and Kevin Monroe as originally specified. $200,000 each, accessible at 50 and 55. The financial exploitation findings, $170,400 in undocumented transfers over 14 months, were formally referred to the Fulton County District Attorney's Office for review of potential criminal charges under Georgia's elder abuse statutes. Raymond Polk's conduct in the matter was referred to the Georgia State Bar for investigation. I heard all of this in courtroom 4, sitting straight in my chair, my hands folded on the table in front of me. When Judge Morrison finished reading, the room was quiet for a moment, and then it was not quiet anymore. There were voices, movement, the sounds of a preceding ending. Darnell stood. He picked up his briefcase. He looked at me across the room, the full length of it. Nothing between us, and for a moment I thought he was going to say something. He didn't. He turned and walked to the door. Before he reached it, I said quietly enough that only the people near me could hear, "What your father asked of you was that you honor this family." Today, I did that for him. He stopped for just a moment. Then he went through the door and was gone. Veronica put her hand briefly on my arm. Patricia was already coming through the gallery gate, and I sat there for another minute in that serious little room with its dark wood and its fluorescent light, and I let myself be finished. 6 months later, in the spring of 2025, I planted new roses along the front walk. The Buckhead house still belongs to me. I had considered selling it. Veronica mentioned once carefully that I had the resources to live anywhere I chose, which is the kind of thing people say when they want to give you permission to leave. But I did not want to leave. Gerald had lived in this house. His books were on these shelves. His chair was in the study. The scratch near the edge of the kitchen table from the stapler he set down without looking in 2003 was still there. And I found as the months went on that I was not ready to live somewhere that scratch wasn't. Darnell was under active investigation by the Fulton County District Attorney's Office as of the spring of 2025. He had not been charged, but he had been contacted, which is a particular kind of waiting that I understand is not comfortable. His Sandy Springs house was listed for sale in February. Kevin had written me a letter in November, not a long one. He did not try to explain or minimize what he had allowed to happen. He said only that he was sorry he had stood in that room and said nothing, and that he understood if I never responded. I read the letter several times over several days. I put it in the fireproof safe, not with the legal documents, but separate from them. I had not yet decided what to do with it. That felt right. Some things deserve to be decided slowly. The $500,000 life insurance policy had paid out in April of 2024, 2 weeks after Gerald died, directly to me. No will required, no contest possible, exactly as Gerald had arranged it in 2004, without either of us knowing how much it would eventually matter. The JMS Holdings Trust transferred in November 2024. The investment portfolio and retirement accounts were released from freeze and restored to my sole control by December. I was not a wealthy woman in the way that word gets used carelessly. I was a woman who had spent 38 years building something carefully and who now had what she had built intact, which is not the same thing as wealth. It is something quieter and more durable than that. In April of 2025, at a ceremony in the Camille Olivia Hanks Cosby Academic Center at Spelman College, I announced the establishment of the Gerald T. Monroe Financial Literacy Endowment. $50,000 per year in scholarships for Black women studying accounting and finance, paired with a weekly mentoring program that I teach myself on Thursday evenings. Because Thursday evenings are when Patricia used to come over with takeout from the Ethiopian place on Ponce de Leon, and I found I needed something to do on Thursday evenings that felt like it was pointed towards something. The program has a name. It is not the Monroe Legacy. It is not in memory of Gerald T. Monroe. It is called The Money They Said We Wouldn't Understand. Patricia stood at the podium and introduced me at the ceremony in the building at the college, where we had both become who we were going to be 47 years earlier. She was wearing the gray blazer. I was wearing the earrings Gerald had given me for our 30th anniversary, small gold hoops that I had not taken out since the day he died. I still have coffee in the garden most mornings next to the roses. I still talk to Gerald sometimes. Not because I think he can hear me, but because 38 years of telling someone things doesn't stop cleanly just because they're gone. It tapers. It finds a new shape. Last Tuesday morning, I was out there before the light had fully come up, and I was looking at the roses, and I thought about what he had written on that piece of paper tucked into page 284 of a book he loved. I hope what I've left behind is enough for you to protect yourself. It was Gerald. It was more than enough. Gerald didn't leave me money. He left me time. Enough of it and just barely to save myself.